This final panel is titled DEI in the Workplace and on Campus, Following Students for Fair Housing or Fair Admissions. And I think that this panel is unique among the ones that we've had today because whereas what we've spent a lot of time discussing, originalism and sort of heady ideas, this is a panel that, you know, your mother or your sister, your brother, somebody who's not an attorney probably has some strong thoughts on. And although we're going to discuss things like equal protection and other sort of nuanced legal ideas, this is also a topic that has pure policy components to it. Ideas that things that people can form their own opinions on and without being a lawyer probably have something relatively intelligent to say. So my final order of business is to introduce our moderator. Today, moderating this panel will be Judge Joshua Wolfson. Judge Wolfson is a United States District Judge for the Eastern District of Pennsylvania. And prior to taking the bench, the judge worked at the law firms of Dilworth, Paxton, and Covington and Burlington. And prior to entering private practice, he served as a law clerk in the same court in which he now sits, the Eastern District of Pennsylvania. Judge Wolfson is a graduate of Harvard Law School and has been a longtime friend of the Federalist Society. So we are very thankful and fortunate to have him lead us through this discussion. Thank you.
All right, thanks. We have a pretty full house up here for this panel, as you can see, so I'm going to stand. I've got my own starting five here. I'll stay out of the way. I'll be our Norman Dale. We'll see who on the panel can prove to be Jimmy Chitwood. I'm going to do, we have a lot to cover, and I'm sure people want to hear substance. You all have materials that cover our panelists' bios. I'm not going to recite them for you all. I'm just going to introduce folks very quickly, and then we'll get into it a little bit. So let me just, I'm going to go from left to right here. We have Andre Douglas Pond Cumming is the Dean of Widener University Commonwealth Law School. To his right, I have the Honorable Janet Dillon, who's the former chair of the EEOC. To Janet's right, I have David Latt. David is the author and publisher of Original Jurisdiction and the founder of Above the Law, amongst other things. To David's right, I have Jonathan Berry, who's the managing partner of Boyd & Gray, PLLC. And then at the far end, to Jonathan's right, I have Todd Clark, who is the Dean of Delaware Law School. So I want to thank them all for taking some time with us today to talk about some really interesting issues. What we're here to talk about is really diversity in the workplace, diversity on campuses, and the status of that in the wake of the Supreme Court's decisions last year in the Students for Fair admissions cases involving both Harvard and the University of North Carolina. So I've got some things I'm going to cover. I'm going to hope that people jump in as we go. And that we have a robust discussion, as with any oral presentation. My hope is we don't get through our outline, and I also hope that you all will jump in with questions. So let me start with the SFFA cases themselves, and let's just get a quick overview of those cases and what happened and what the Supreme Court held, and why a holding in a case about admissions in college might have implications for all of these different areas of our lives in terms of both activities on campuses and both hiring and other things in the workplace. So maybe I can just start out and I think I'll ask Janet in the first instance to give us a quick overview of what happened in SFFA.
So in the SFFA, what the court did is held that the use of race in college admissions was unconstitutional under the Equal Protection Clause, and it also violated Title VI of the 1964 Civil Rights Act.
And so as we get into that and we think about that, you say Equal Protection Clause, most employers aren't the government. Title VI deals with educational institutions. Just broad strokes, what about the holding would suggest that it's going to have applications beyond the area of student admissions?
Well, interestingly, in Justice Gorsuch's concurrence, he noted that Title VI of the 1964 Civil Rights Act, it was the next door neighbor to Title VII, which governs discrimination and prohibitions against discrimination in the workplace. Now, the SFFA cases did not deal with discrimination in the workplace. They dealt with college admissions. But a lot of commentators looking at the court's reasoning and thought process said, well, hold it, doesn't this have implications for the workplace? I think it's important to note, though, that unlike in the college admissions context, the Supreme Court has never held that interests in diversity and having a diverse workforce allow an employer to engage in race-based or sex-based decisions in the hiring, promotions, or making other significant workplace decisions. So the whole context in the employment space was different prior to SFFA than it was in the education context.
Great. So let me ask about sort of subsequent developments. We're now about a year past the SFFA cases coming down. And so let's talk about, first of all, have there been other cases? I know, Janet, and I don't want you to I don't want to keep putting you on the spot, but I mean, I know there's at least been one decision, the Muldrew case, that maybe is worth having you talk about. And then I'm curious what other people can tell us about what other courts have done or what's come from a regulation standpoint. But maybe you can start with the Muldrew case.
Sure. So Muldrew versus St. Louis was another Supreme Court decision. It was handed down this term. The court, it was a 9-0 decision on the judgment, although there were 3 justices that authored concurrences. But Muldrew, unlike SFFA, actually dealt with Title VII. And it held that the requirement for showing injury to state a cause of action under Title VII is that there must be an injury. Seems pretty straightforward, but various circuits around the country had defined this injury requirement differently, and most had grafted on a requirement that it must be a substantial injury. There must be a material injury. It must deal with the ultimate employment decision. But Justice Kagan, who authored the majority decision, said, no, those words don't appear anywhere in Title VII. We're going to read Title VII exactly as it is written, which is the plaintiff must just show some injury. What this means is that it is now easier to state a claim for Title VII in those jurisdictions where the courts have grafted on this additional requirement. And hence, it's going to be easier for plaintiffs to bring claims based on certain kinds of DEI practices that they might consider to be objectionable in the workplace.
And so let me sort of ask, and maybe Jonathan, I'll start with you on this. Have you seen developments in the courts since SFFA has come down, since over the past year, that can shed some light on how it's being applied by courts of appeals or district courts?
So there's a little bit that's happened in the wake of SFFA. So, for example, here in this district, in the Eastern District of Pennsylvania, a professor brought a case against Penn State that alleged a hostile work environment on the basis of sort of racially separated trainings. And the court earlier this year, post SFFA, denied Penn State's motion to dismiss. They said that claims that being subjected to these trainings, where he was accused of promoting white supremacy, that was potentially actionable as hostile. There's also, I believe there's a Fifth Circuit case extending this in the as against a sort of minority preferential program, I think from maybe the Louisiana State Bar.
Okay.
As well.
We've got a couple academics on the panel who not only are academics but who have to deal with the administration of their institution. So let me sort of maybe start at the far end there with Dean Clark and ask, how about in the context of on campus, have there been developments that you've seen maybe either coming out of courts or regulators that have impacted, applying SFFA in a way that has impacted what goes on in your institution?
I would say yes. I think that it's had a major impact on higher education. One of the things that happened recently is there was a dean's conference, and in that dean's conference, we specifically talked about how SFFA will change the way that we conduct our admissions process. And one of the things that initially happened is most law schools began to change their law school application to reflect the process that was required by SFFA. And then the other aspect, although SFFA only dealt with admissions, there was a lot of conversation and confusion about whether it also applies to scholarships and do we apply it beyond that context. I think that different deans across the country and in law schools across the country are going to have different perspectives on that, but it has definitely invoked a lot of discussion and a lot of uncertainty about how to proceed forward. I think that I am one of the proponents. I think that there's a lot of value in having diversity in the classroom, whether it's diverse perspectives, racial diversity, gender diversity. I think it adds to the richness of the classroom experience. And I do think that the SFFA case may make it a bit more difficult to get the racial diversity in the classroom.
And I have to add anecdotally, so as a graduate of Columbia Law School, I should note CLS shortly after SFFA announced, all right, we're dropping our sort of racial data collection for applications, but you need to submit a video interview. That I think that got rescinded within 24 hours. Columbia's been stepping on a lot of rakes recently.
And how about coming from your standpoint, but whether admissions, but also hiring? I mean, has it impacted, the way you're conducting things from an administrative standpoint at the school?
Thank you for the question, and I just wanted to briefly say I'm delighted to be here with you. I've spoken at the American Constitution Society dozens of times, had the pleasure and blessing to speak all over the world. This is my first invitation at the Federalist Society, so thank you for having me. Hopefully you'll have me back at some point. Thanks, Judge Wolfson, for moderating us. Thanks for my fellow panelists. Also to Dave and Hannah and Zach for inviting us here. I wanted to take a step back, if I could, and talk about SFFA for just a second.
Sure.
I read the opinion when it first came out. I read it again this morning on the train in from Harrisburg. And I wanted to mention that by my reading and some of my scholar friends, Chief Justice Roberts' holding is pretty narrow. Mm-hmm. He actually finds that Harvard and UNC run afoul of the Grutter opinion, essentially, and in that respect holds that they unconstitutionally applied their affirmative action programming. But one of the things that's really important that Chief Justice Roberts says, I think, in the end of his opinion is that surely we all agree, speaking of the 9 justices, that it's fine for a student to talk about their overcoming difficulties in their life, to talk about their race, to talk about how that impacted them, so long as the institution doesn't apply their race specifically, but their overcoming of difficult circumstances in the mission of a diverse class as still constitutional. So there are some that argue, Stephen Ramirez, a friend of both Dean Clark and I in the Seattle University Law Review, that affirmative action is live and well, just not practiced properly at Harvard and UNC, who very specifically took race into account and tried to do racial balancing in their classes. So to the video point that Jonathan suggests, probably not a video interview, but students can still definitely talk about their race and how their race impacted their life and their coming up. And so long as they tie that into overcoming obstacles in their life or showing courage or diversity in some sense, that is still a way that law schools can continue to admit people that are of diverse populations or formerly discriminated against populations. So some would suggest that affirmative action just wasn't practiced smartly by Harvard and UNC. So as far as the question specifically, thanks, Judge, about hiring, one of the things that's really important is, I feel like, and I think many deans across the country would agree, that hiring diverse faculties is important. I tend to view diversity as very broadly. So I look at diversity as not just racial, not just gender, but also worldview, also religious diversity, et cetera. What we do in what I've done historically in my hiring efforts has always been to look for diversity writ large and broadly. And I don't think SFFA has changed that at all as far as our hiring is concerned. We look for folks to apply to our institutions that would bring diversity into the classroom broadly and that would actually relate to our student populations who are also becoming, at least increasingly at our institution, more and more diverse.
So let me go back to the first point you made with respect to the comment at the end of Justice Roberts' opinion in
Yes.
SFFA, because it certainly has been the subject of a lot of discussion and debate. And I think what I heard you say was affirmative action is alive and well. So maybe we have a definitional question to start with, which is, how do you define affirmative action? What would you say it means when you give that answer? And then I want to sort of throw that open to the panel and see what their thoughts are on
Thank
that
you. I'm
as well.
happy to take that first and then hand it to David.
Yeah.
So under Grutter, right, so under Grutter, which relied principally on Bakke and Justice Powell's opinion, and then Justice O'Connor and Grutter, and then later Justice Kennedy and Fisher, they eliminate racial quotas. They eliminate race-specific as a determining factor, but they say for a mission of diversity in the classroom, then a plus factor of race can be considered. So that's sort of where the law has generated from. And I read Chief Justice Roberts' opinion very carefully 3 or 4 times, and I don't feel like it overrules Grutter. I think the opinion says that Harvard and UNC did not follow Grutter. And so from that perspective, affirmative action is alive and well. If you're talking about affirmative action as a mission for accomplishing a diverse classroom and a diverse experience in a law school. So that's how I would define affirmative action.
And David, yeah, your perspective is still alive and well?
So I have a somewhat different view than Dean Cummings. He is correct that this was kind of a Roberts Court special of let's not say that Grutter is overruled. But I think that post-SFFA, I think Grutter is effectively a dead letter. I take a broader reading of the court's opinion than Dean Cummings. What I would say, and I think this is the reason why people were so up in arms about SFFA. If it was just a refinement of Grutter, I think people wouldn't be as upset or as animated about it. So in terms of how we define affirmative action, I actually prefer the term racial preferences. I think you could think of affirmative action as outreach to minority communities, encouraging them to apply to elite institutions because, hey, you might get financial aid that makes this more affordable than your local college, or things of that nature. I think what we're talking about with affirmative action is we're thinking of racial preferences. And I think the way I read the Chief's opinion is post-SFFA, racial, you can't consider the way I like to put it, and the Chief has something similar to this, is you can't consider race qua race. So the opinion that Dean Cummings, the language that Dean Cummings referenced near the end of Roberts' opinion, where he says, look, if you've had some kind of life experience, perhaps overcoming adversity, and that overcoming of adversity is related to your race. For example, you're the victim of discrimination. You can talk about that. Nothing in this opinion prevents you from writing an essay about how you overcame discrimination on account of your race, sexual orientation, being transgender, what have you. Nothing prevents you from talking about that. But what I think the opinion gets rid of, and when Dean Clark talked about revamping applications, I think this is what he was referring to. You can't just check a box and get a benefit from that. You can write in your essay about overcoming racial discrimination. You can have your recommenders talk about how you overcame discrimination, you demonstrated grit and resilience. But you can't just check a box and say, I'm X or I'm Y, therefore give me a bump up. And I think that is a break with past law. And I think that is why you're now seeing a spate of lawsuits in the employment space, for example, because people are reading this opinion more broadly. Now, maybe this is an overbroad reading, but I would even say that the Chief's opinion embodies what you see in Justice Harlan's great dissent in Plessy, the vision of a colorblind constitution and colorblind laws. I'm a huge fan of both Justice Harlan's. We named our oldest son Harlan. And so we're kind of like Harlan junkies in our house. But, that's how I read the opinion. I think it's a broader opinion. And that's why I think people are now worried about its implications, because employers read this opinion and they say, wow, I can't I really, to be on the safe side, I probably shouldn't even ask about race. Now, if the person tells me in the interview, when they say, tell me about an important experience, well, I overcame this type of discrimination, and by the way, it was racial discrimination, that's fine. But you can't just check a box and get a benefit anymore.
So, Jonathan, the Department of Justice issued guidance following SFFA, right? And part of what they said is you can conduct a holistic application process as part of the admissions process. What do you think that means?
So I think it's taking that verbiage at the end of the chief's opinion and encourage. Further examples would be from DOJ. A university can consider an applicant's explanation about what it means to be the first black violinist in a city youth orchestra, or something of that type. So that on the one hand, I think does take real steps to actually contextualize race and move its discussion to a role that can be compliant with the law. I think the challenge is going to be that it's still going to be very tempting for both lots of university or job applicants, for that matter, applicants on the one hand and administrators of admissions decisions on the other hand, to essentially use race as a proxy for disadvantage, and to the extent and at a consideration that is a sort of a proxy move that is not permitted by law. That principle was directly discussed in the ruling striking down one of the minority set-aside contracting programs recently, where race was used as the statute. I believe the statute actually says historically disadvantaged minority or historically disadvantaged person. The SBA's regs said that equals kind of every listed race except white. This despite the fact there are plenty of people who have not had those experiences of discrimination in the way that you would normally think of.
So let me ask a question, and I haven't floated this with anyone, but based on what you just said, Jonathan, what about the inverse, right? So a lot of colleges changed their essays that were required following SFFA. Can you use some sort of disadvantage as a proxy for race? You said you can't use race as a proxy for, disadvantage. What about the inverse?
I guess I'm trying to understand what the.
So tell me about. I'm going to press for people to talk about ways disadvantage in their lives impacted them. That's a necessary essay, right? Yeah. And in seeing that, we think that will help us achieve a racially diverse class, which is what we really want. And maybe we think that it's not at least explicitly allowed anymore under SFFA. So, David's nodding. Why don't you jump in?
So
on this?
I think, what the judge is alluding to is there used to be these sort of diversity statements, sometimes in applications for educational institutions, sometimes in applications for faculty positions. And a lot of institutions post-SFFA have understandably gotten rid of an explicit diversity statement. And now they ask more open-ended questions like, please tell me about a time when you overcame adversity. And, it's kind of like a hint, hint, nudge, nudge, kind of whip out your violin and talk about how, so I'm Asian American, I'm gay. Well, let me tell you about the time that I got bullied for being Asian American, and then the time that I got called a slur for being gay, and let me, kind of play the whole violin. So I think that is sort of what's being invited by these, telling me about adversity. And now, because I couldn't check a box saying I'm Asian and I'm gay, now they know from my essay, he's Asian and he's gay. But what I like about, what I think is not as pernicious about these essays is, and this is why I think the institutions, and you saw this at oral argument at SFFA, I think Harvard and UNC, I wrote this in a post on original jurisdiction, I think they got hoisted by their own holistic petard, because they kept on saying, we have these amazing holistic probing diversity admissions processes. And, race is just one little bit of the mosaic. They check a box, sure, but we consider so much stuff. Well, if you consider so much stuff, if you consider recommendations, if you consider essays, if you consider all of these other things, activities, what have you, what value are you getting from the box? You're getting no value. If somebody overcame discrimination because they're gay or because they're of a certain race, that'll show up in the essays, that'll show up in the recommendations. The verbiage at the end of the chief's opinion allows for that, but no benefits just for, checking a box. And I think, what is so perverse, I think, about just, this is, not really on the constitutional point, but this is just a policy point in terms of just the judge's question about, disadvantage and race. They're not always correlated. And I think what's good about a system where at least you have to sort of, ante up and write an essay is you need to actually show how race or gender or sexual orientation or gender identity made a difference in your life. So my husband and I, we have 2 sons, and we had them through the amazing miracle of surrogacy. Our egg donor is Black and Latina. So our sons are Black and Latino. But they live in a very privileged environment, 2 lawyer dads, upper middle class, suburb, etc. If they wrote an essay, I hope that someday they will not be able to write an essay saying, oh, these terrible things happened to me. But they can't just check a box being like, oh, I'm Black and I'm Latino, give me a benefit. Whereas somebody who grew up in a basic, de facto segregated area and overcame all this racial discrimination, they'll be able to write a great essay. So why should my son, who just by genetic accident happens to be Black and Latino, get a benefit when he hopefully will not suffer this kind of discrimination, and somebody else who actually did suffer discrimination, they can write about it. They can have recommenders. People can look at the school they come from. Like all of that. Like this is what I think as a policy matter is so perverse about, again, I'm not going to call it affirmative action, racial preferences.
So let me shift gears for a little bit, unless someone has a burning desire to respond to that.
I do have
Okay,
a
go ahead. So go ahead.
I do have a burning desire.
I'd like to speak.
My first thought is they might get bullied. They're named Harlan.
Our other son is named Chase, another great justice, or justices.
Around here, most people think that means you named him after a second baseman.
Or a bank. Yeah.
Or a bank.
So I, for 20 years, have sat on admissions committees. I don't know how many of you have had that experience, but I have read thousands of personal statements, and I don't know how many of you have had that experience. But I just read one yesterday, a Liberian refugee that came without his parents to Baltimore and lived with his grandmother, and had a gun put into his, a gun put to his face twice in his life. I mean, you read these essays, and you're like, good Lord, this person needs to be a lawyer. We need to have this diversity in our class. And so I would really like to challenge us to sort of shift away from thinking, I think Harvard and UNC were lazy in their processes. Check a box, and we're going to say that race means disadvantage means diversity. What we're really looking for, I think this is probably true for Dean Clark, but what we're really looking for is an enhanced, fabulous classroom experience that includes Liberian refugees, and that includes people that have overcome really difficult circumstances, and having taught first-year classes for 20 years, and being able to have those kinds of people commenting, those experiences commenting in your classes makes an amazing, diverse classroom experience. That's the goal. And what I think I'm trying to say, what I know I'm trying to say, is that when I say affirmative action is live and well, is what I'm trying to say is this diverse classroom experience, if we can figure out a way to get it without saying, I'm assuming that you had a tough life because you're Black or brown or gay, but instead saying, tell us about how you overcame, and let us let you into our law school class so that we can have this robust, diverse experience in class. That's what we're seeking. And what I think SFFA did is it just eliminated the laziness in admissions committees from being able to proxy race for disadvantage or proxy race for overcoming. I went to Howard Law School, and I was flummoxed in my first year contracts class with all of the kids of lawyers that were in the class. It was an amazing experience. I loved it, but they weren't disadvantaged. I don't think many of them weren't. And there were very few people that looked like me in the law school class, but I grew up in, the mean streets of LA. I might have suffered a little bit more than some of my classmates did, but that's what I think I'm trying to talk about. That's what I'm seeking, is this really diverse classroom experience, and getting there in a way that doesn't just proxy race for disadvantage or diversity.
I totally agree with what Dean Cummings said, and that's why I'm glad some opponents of affirmative action say, oh, I wish the chief hadn't left this escape hatch at the end. This is why I support the escape hatch. Like, this is a very valuable form of diversity, and you should be able to consider these things, and you shouldn't have some extreme thing where anything that happens to be vaguely related to race can't be talked about. So I agree entirely.
And so I echo both of those sentiments. And one of the things that's a bit, interesting is that I wonder how much SFFA is really going to change the landscape of admission, because as you see, a lot of law schools have what they have done is they've modified their application, and now students are just going to tell the story. And based upon those stories, there's going to be a compelling reason to admit that student because of the narrative that the student has shared. If the statistics in terms of law school enrollment remain the same as they are now, then there's been no change. The only thing that has happened, instead of saying, I'm giving race a plus factor, I'm just going to make the decision based upon the student story. So if we are at the same position that we would have been in before, or that we were in previously, what is the real impact? And I'm really curious to see what happens going forward with the SFFA case, because I think that there's also this undertone, which is that if you consider race as a plus factor, that somebody is getting an opportunity to attend the school that's less deserving than somebody else. But I think if we see that doesn't change the end result, where we still have the same amount of diversity, I'm really curious to see what the sentiment or what the attack will be. And then does the attack become the relative does it become this analysis of the narrative that the student is telling, that to say that, wait a minute, that student told that story, but you shouldn't have omitted them for that story because this other student had a better story. Like, I don't know how you would litigate that. Like, how could you attack a law school for omitting a student based upon his or her story is really where I'm going with that.
I guess I would say if the trend lines don't change in the wake of SFFA, then that's a suggestion that there is something amiss with what the sort of the loophole, as it were, that the Chief Justice left open. Because I agree with what the opinion says as a formal matter, that aiming at disadvantage and talking about kind of anything that may feed into disadvantage is totally right and proper. The challenge is going to be that it's the same admissions professionals from that same professional culture, the professional culture that has historically given all manner of crude or subtle preferences on the basis of race. It's not as if there's been some sort of systemic reform to who those people are, and now there's a permission structure specifically for this is how you're supposed to convey the fact of your race going forward. I agree in concept that doesn't have to be abused. If the numbers don't change at all, that's a real smoking gun. That's a real suggestion that that it is being abused.
And I think that goes way further than what the opinion intended. I think that's a scary proposition to say that diversity should decline because of the case, because that wasn't the essence of the case. The essence of the case was, instead of using race as a plus factor or using race as a basis to admit instead you have to talk about stories that a situation that you've overcome and how that contributed to to your ability to add to the educational experience. And I don't think that means that the trend line has to change. I think that's really scary to me, if there's a belief that the trend line has to change because of SFFA.
Let me, before we leave the campus setting, we're talking about admissions, right, which is where SFFA comes up. But what about non-admissions programs on campuses? So scholarships, honors programs, other on-campus opportunities that may exist for students. Does SFFA preclude the consideration of race in those areas as well? Maybe Janet, I'll start with you.
I think that the logic of the majority opinion in SFFA holds true for those kinds of programs on campus as well, whether it's an honors program, other kinds of advantages in the academic setting. I think the same logic would apply.
Dean Cummings, you have a different view?
Yeah, I don't. I've heard of some law schools that have set-asides and quotas for law review seats, and that have sort of preferences for a moot court team or what have you. And I think that those would, if challenged, be struck down as quotas and violative of SFFA. So law schools are going to need to be creative if they're interested in truly diverse classes, without proxying check the box and you're automatically diverse.
Right. Okay, let's go beyond the campus setting. And you know, we alluded to this earlier. SFFA was decided, or at least the Harvard case was decided under Title VI exclusively. The North Carolina case had a constitutional component as well. And so there's a few statutes that this has potential implications for in the employment setting. Certainly Title VII, which is, as we said, the neighbor. Section 1981 is another common statute that gets evoked. The Supreme Court has at least blessed the idea of some affirmative action in the employment space. I think that was the United Steelworkers case. Janet, maybe you can tell us just briefly about that and where you think that stands now.
Yes, so there's actually two opinions that the Supreme Court handed down, essentially blessing, as you said, voluntary affirmative action plans in the workplace. There was United Steelworkers versus Weber, which dealt with a set-aside for African-American employees for a training program. And then there was a decision in 1987, Johnson versus Transportation Agency of Santa Clara, that dealt with promotion of women. And in both of these cases, the situation was that, in the first case, African Americans, in the second case, women were historically underrepresented, and had been discriminated against deliberately and intentionally. And so both employers put in place programs to try to address that historic discrimination. And the Supreme Court, again, late 70s and 80s, affirmed those programs, but on very narrow grounds. So it viewed these programs as very narrowly. The programs had to be designed to address specific past discrimination, so not general interests in diversity, but specific discrimination against a group. The program to address that discrimination had to be narrowly tailored and could not unduly trample on the rights of the majority population. And the programs had to be limited in time. So once the objective was achieved, the program needed to end. It could not continue to maintain a certain balance of diversity within the workplace. So, and the EEOC has some regulations that follow these two cases. They're extremely narrow, and I would argue that they only apply in very limited circumstances where there has been examples, demonstrated examples of deliberate discrimination against a group. That said, would they survive, this court's, approach to the reading of Title VII? And I think that's an open question, because we've seen both in Muldrew, the decision I alluded to earlier, as well as last term a case called Groff versus DeJoy, which dealt with religious accommodations in the workplace. That was a 9-0 decision. The court had no problem reading Title VII as it was drafted. So we, in 2 years, we've had two Title VII cases where in each case, 9-0 decisions, the courts have taken a very textual approach to the language of the statute. So that being said, would this court uphold Weber and Johnson? I think it's a real open question whether they would.
Jonathan, you want to jump in?
Yeah, I think on the law, right, so that the statutory holding with regard to SFFA, Title VI, not Title VII, exactly how those two relate is somewhat contested. What is not contested, or what would be directly relevant to any Title VII, the ability under Title VII of using, say, diversity as a rationale, which the courts do not recognize at the moment, is what the court did in considering Harvard and UNC's proffered rationales for diversity, and the court specifically disapproved those. So that justifications including the need to train future leaders, prepare graduates for pluralistic society, educate students through diversity, produce new knowledge from diverse outlooks, even encourage enhance cross-racial dialogue. These were things that the Supreme Court, under strict scrutiny, in those cases, found to be too amorphous and not usable as modes of evaluation. That rationale ought to carry straight line over to any Title VII conversation. The other thing to note very briefly, underscoring what Janet said about the limits of the Weber and Johnson line. Weber in particular, of course, it's so decided, I believe, in 1978, relating to an affirmative action plan imposed, I believe, in 1971 in Louisiana. This was a state that until 7 years previously had de jure segregation until that was outlawed in 1964. The remedial rationale is far stronger in that setting than anything we have, to the best of my assessment, in the United States today.
So I heard an allusion to, considering racial, race explicitly in the, employment context as we think about potentially rectifying historical imbalances. One place where that happens quite a bit and quite explicitly is in public contracting. There are routinely RFPs issued that have small, diverse business requirements as part of them. Are those still permissible, do we think, after SFFA? Are they going to survive, the Supreme Court's holding? Let me. If anyone wants to jump in, they can. Otherwise, I'm going to go Socratic and call on you.
You want to start? You want me to start?
I have a lot of views, but I've talked a lot.
I'll start, and then you can do cleanup. Yeah, I think we're already seeing it. I think this was coming anyway, but I think that this is kind of. I think the SFFA case has kind of focused the attention in this area, and so you are seeing more challenges to these kinds of set-aside programs, and I think they're successful challenges. One case that I think, Jonathan, I think you alluded to it earlier, was a case out of the Northern District of Texas, a decision by Judge Pittman, involving the U.S. Minority Business Development Agency, which dealt with credit access. And there were set-asides and preferences given to minorities with respect to credit access. And the court appropriately applied strict scrutiny, found, yes, the agency did have a compelling governmental interest in remedying past discrimination, but the program itself did not survive strict scrutiny. And the reasoning was, had echoes of SFFA because, the court pointed out these preferences were both over-inclusive and under-inclusive. White, poor applicants would not be benefited by this program, but Oprah Winfrey would. And that was the exact example that the judge used to say, this is why this kind of program cannot survive strict scrutiny.
Yeah, and I would add only that the analog is we're already seeing to start to unfold in the private contracting context as well, where Section 1981 is a flat ban on race discrimination in private contracting is starting to get deployed as well.
Well,
and it's also being employed in the employment context too. Slightly different requirements, but there are definite advantages to bringing a Section 1981, a cause of action under 1981 in the employment context. Longer statute of limitations. There's no pre-suit requirements of filing a charge with the EEOC, and the same cap on damages does not apply. So a 1981 suit potentially, is of greater risk to an employer than an action brought under Title VII.
And I think we've seen this, and I don't know if anyone wants to talk about the Fearless Fund case that the 11th Circuit decided recently, which I think is another example, Jonathan, of what you're alluding to. A case involving a program for applications for, I believe, black women, I think, in Georgia, and court struck it down and said, invoking SFFA, I believe, to say this just can't stand. Is that sort of where we're headed? Are there going to be more of these cases, do we think, that are going to strike down these types of minority efforts? David, what do you see for that?
Sure. So this case, Fearless Fund, was out of the 11th Circuit. The majority opinion was by Judge Kevin Newsom, and Fearless Fund was giving financial support to or investment to businesses that were essentially founded or run by Black women. And this was the subject of a lawsuit. And under so Section 42 USC 1981, which has been alluded to previously, bans racial discrimination in contracting. And the court found that it applied to this case and that the fund could not do this. Now, there was a dissent in this case by Judge Robin Rosenbaum. And this, I think, is going to actually be the tricky issue in these cases. It was one of standing. So a lot of these cases involve sort of like associational standing, not someone who's like, oh, I applied and, I individually suffered some kind of rejection. But there's an organization like Students for Fair Admission at Harvard. So, for example, two organizations that are filing a lot of these lawsuits. One is called the American Alliance for Equal Rights. It's by Ed Bloom, who was behind the SFFA cases, AAER. And another organization by former Trump, or maybe current Trump advisor Stephen Miller, America First Legal, and they've been filing some of these lawsuits too. And so there's this issue of standing. And Judge Rosenbaum didn't say, well, it's okay that they're making this money available only to Black women-owned businesses. She said that there was no standing. She did not go to the merits. And there was a recent case where a district judge turned away a lawsuit, but it was also on standing grounds. It was a lawsuit against NYU for, Dean Cummings was alluding to this. It was for racial preferences in law review selection. Mm-hmm. And again, the judge didn't bless it and say, go ahead, discriminate, have a nice day. Mm-hmm. The judge said there is no standing because, again, it was one of these sort of, amorphous cases. It was not a clear case of I applied, I got rejected, I can prove that some less qualified person got it over me because of race. It was not something that clear cut. So standing is going to be a really key issue in a lot of these cases.
Do you, let me ask the deans on the panel, do you see these cases impacting, for instance, your procurement processes?
Procurement processes for the law school or just in general?
Well, for the law school in particular, or the institution with which you're
or
associated more generally.
Hiring? I don't know.
No, I'm thinking more like actual going out.
Contracting.
The contracting, the potentially emphasizing or preferring minority vendors and things like that I think a number of schools have often done in the community to try and enhance the communities in which they reside.
That's actually a really good question, and I hadn't thought about it from that perspective. I'm sort of thinking about the process that I would utilize for the procurement type questions that you've mentioned, and I mean, I can't see it changing the way that I engage in contractual relationships with third parties. One of the primary contractual relationships I enter into as a dean is if I'm bringing in an adjunct to teach a course, right? Or if you're just talking about, let's say I have renovating some space in the law school, and we'll do a request for proposals. And, I don't know that we've ever specifically said we're only taking minority proposals, but I can see how this, or specifically requesting that minorities submit.
You don't, just to be clear, you don't have an SDB component to your procurement, to your RFPs?
No.
If today's June 21st, that means I've been on the job 21 days. So I don't have any idea of how our procurement works. I'm trying to figure it out as we go along. But I did want to take this opportunity to just pivot to what I think is the next big issue.
Yeah.
In light of George Floyd and Breonna Taylor, law schools across the nation started opening centers. Center for Racial Justice, Center for Equality, Center for Criminal Justice Reform. You probably know the ABA put out a standard 303C that says that we have to, in our law schools, teach bias, cultural competency, and racism at least twice in the law students' experiences in law school. And so with all of these centers popping up around the country for racial justice and criminal justice reform, and with this new standard 303, I think that's going to be the next fight. I think that we're going to, at my former institution in Arkansas, we were trying to put together a class that satisfied 303C, that taught cultural competency, bias, and racism. and there was a Center for Racial Justice and Criminal Justice Reform there. And as one of the founders of that center, I was hauled in front of the Arkansas legislature, public university, and they said, "Well, why would we need a racial justice center in Arkansas?" I was like, "I've got a list if we want to go through it, but there's going to be certainly scrutiny." In fact, I just read yesterday there's a law professor in Indiana that is battling against the 303C class that was just instigated at Indiana University in Bloomington, and what he called indoctrination of students being required by the ABA. And you probably know, in order to retain our accreditation, we got to comply with the ABA standards, of which 303C says bias, cultural competency, racism in the classroom at least twice in every law school student's experiences. I think those are the next big challenges, will be with the ABA's requirements, with these centers for racial justice that are popping up around the country, as far as compliance with SFFA and what is a Supreme Court or the lower courts going to do when these policies, classes are challenged. And they will have standing because it'll be students that are bringing the challenges for having to take the cultural competency and bias class. So I think that's the next big frontier as far as education is concerned.
Just picking up on what the dean was just saying, Jonathan Skrmetti, the Attorney General of Tennessee, along with AGs from several other red states, sent a letter to the ABA. They have a standard, it may be the same standard, I'm not sure, that alludes to racial diversity and underrepresented groups. They're in the process of amending it, but the amended version, the proposed amended version, still refers explicitly to a racial and ethnic identity, and it is the claim of Skrmetti and these other AGs that that should not be in there, that the standard about commitment to diversity should not explicitly reference racial and ethnic diversity in light of SFFA. So I agree with Dean Cummings that there are going to be fights over these ABA standards.
Just to follow up on that, David, I think there was a letter that was publicized maybe this morning from 19 Democratic AGs.
Oh, I didn't see this.
Taking the opposite view. So, let me kind of, that's a good jumping off point, right? So, sort of for a couple questions, and Jonathan, you're here, you're in private practice, you have a law firm, someone calls you up, and they've gotten letters from both sets of AGs, like, what's a business owner to do?
So start with well, first of all, hire a good lawyer. Second, I think take stock of the landscape. In particular, there's a growing wave of what I would style as anti-DEI investigations and litigation that's coming. You have some of this relates to I think a lot of people who are lawyers who are politically conservative are starting to flag in their reluctance to essentially do plaintiff's work as part of it. There are a tremendous number of EEOC charges being filed these days against corporate DEI programs that are facially, racially discriminatory, filed especially by Stephen Miller, who I think David referred to, as former Trump advisor. It was these amazing ads that look like they come out of daytime TV. Have you been a victim of diversity or equity or inclusion? Call today. All calls are confidential. They're very well done and they're very funny. They seem to be getting actual results. So that wave is coming. And I think the result, given our current judiciary, is that we are going to have a substantially more colorblind system of employment law come into place over the next couple of years.
And so what does that mean going forward for DEI programs? Are they something that an employer can maintain, or do they just have to be set aside? Yeah, go ahead.
I think that's an interesting a point that you make, and I think it's a good point if you say we get to a colorblind analysis. But one of the things that you mentioned earlier was that if we're talking about an admissions context, right, we should have a colorblind process. Mm-hmm. Why would a colorblind process mean that we have less minorities?
I don't know that it necessarily would. What I'm questioning is whether the sort of the current admissions apparatus across universities is actually colorblind. That's an empirical claim, not a
I'm
legal
only
claim.
thinking about to the extent that you said that the trend line should change. That if we see that the statistics remain the same, then that means that there's an undercurrent of maybe some impropriety. And so if we're saying that we're in a colorblind situation, right, why would the trend line have to decline?
So insofar as I guess my position is that we've got, I don't think it's very controversial that there's been these various systems of racial preferences that have come into place over the last several years. And you would expect, all else equal, if those preferences are taken away, that's going to have some kind of effect on these distributions. That's as simple as I'm saying. If there is no effect from the taking away of the preferences, one possibility is that this is a truly colorblind process all along. The other possibility is that there is, in fact, still just more deeply buried the splinter of racial preferences, kind of further under the skin.
Okay.
Let me, going to Dean Clark's question, one of the things that I think you really have to remember about the SFFA case was, this was a case involving Asian American applicants, and the discovery in the trial showed that Asian American applicants were penalized even vis-a-vis white applicants. So this is not your typical sort of standard narrative of Asians and whites versus underrepresented minorities. This was Asian Americans getting dinged relative to whites. And so if Asian American applicants continue to be dinged relative to whites after this decision, I do have to wonder whether something, a little sketchy is going on. One of the things that Harvard got kind of raked over the coals for, it was, well, they had this, and I say, full disclosure, somehow I got into Harvard, I'm an alum of that place, but they had this personal score, and Asian Americans were found to score very poorly on this personal score. Apparently this measures things like personality, sense of humor, extroversion, et cetera, and so we're all really boring, humorless, devoid of personality
I think
people.
You're pretty good on those.
So that, and that's what was hurting Asian Americans vis-a-vis white applicants. And if none of that changed, if we did discovery in a similar lawsuit 5 years from now, we found that Asian Americans were still suffering vis-a-vis whites, I would have to wonder, what's going on here?
Well, I think there was also the definitional issue, too, that I think is becoming increasingly complex as our society becomes increasingly multicultural and multiracial. And I forget, I think it was Justice Gorsuch. One of the justices pointed out, when you talk about Asians, what are you talking about? Exactly. So I think that's another issue that kind of got layered into this, and to the point that the other panelists have made, that really hurted Harvard and UNC because they seem kind of flat-footed on that point.
Actually, it was funny. I think Seth Waxman basically said, well, Asians really are deficient in those things. I'm being, he said it. He's very eloquent. He said it in a much nicer way. But that was basically the upshot.
All right. It's about 4:25, 4:23. I want to give time to the audience for questions, and I don't want to hold you up from the bar. So questions? Anybody? I can keep going. Yeah.
For David, you do a lot of reporting with schools and law firms. How much have you seen in terms of changes? Are you seeing fewer stories now than you were before?
So it's very interesting. I'll talk about the law firm angle. So AAER has filed a number of lawsuits against various law firms that had explicitly on their face racially discriminatory employment programs. Typically, these were 1L fellowship programs. Usually, it's very hard to get a job at an AmLaw 100 firm after your 1L summer. But if you're a racial minority, an underrepresented minority, you could get these jobs at various programs. So AAER filed a bunch of lawsuits, and so far as I'm aware, every law firm that they've contacted, that they've either sent a letter to or filed a lawsuit against, has folded. I'm not aware. It was interesting. Winston and Strawn was said, well, we're going to fight this. And then lo and behold, they folded too. Now, what do I mean by folded? I actually think this is a very good thing. What they did was they changed the criteria for these diversity programs to say it's no longer about whether you're a member of a particular racial or ethnic group, but what have you done to advance diversity in your community? And that could very well be a white person who is an ally of the minority community, and that person could also be considered for these diversity fellowships at these law firms. So in terms of law firms that have, basically stepped away from on their face racially discriminatory fellowship programs, you have Winston and Strawn, you have Perkins Coie, you have Sussman Godfrey, and I don't mean to be like too cynical. I love law firms. This is like what I write about. But one thing that law firms are very good at is, it's like that famous quote about Goldman Sachs, like the squid that just sticks its funnel into money or whatever. Like law firms are very good at finding new practice areas, and many of them have developed this practice area of DEI consulting, where they're basically going to say to employers, hey, here's how either, we'll prevent you from getting sued, we'll review your compliance, we will defend you in lawsuits. So it's kind of like physician heal thyself. It would look really bad for a law firm to be on the losing end of a 1981 or Title VII lawsuit, and then they will purport to go to GM or IBM or whoever and say, let us tell you about this. Oh, we know about this because we got sued. Like, that's not a good look, and that's why the law firms have been changing their policies, and I think for good ways.
Yeah.
John Marshall Harlan, the first infamous dissent in Plessy, infamously said the Constitution is colorblind, but it also says it knows no caste. And my question is, what does SFFA have implications for in regards to legacy admissions, which inordinately favor wealthy Caucasians? And in particularly in light of Chief Justice Roberts' opinion that amorphous ends don't justify discrimination, amorphous ends could be defined to include keeping fundraising spigots open.
Let me just, and just to add to that, okay, because it's something we sort of touched on earlier, because I think when you talk about legacy admissions, when we talk about some of these other programs, do you foresee waves of disparate impact claims coming, on the heels of SFFA as you look at some of these programs that, maybe are intentionally or unintentionally creating, racial biases one way or another?
I think a lot will depend on whether the schools follow SFFA in good faith or not. Some of you may be aware of the Fourth Circuit litigation where Justice Alito filed a dissent from denial of cert over the Thomas Jefferson Magnet School in Northern Virginia. TJ, Coalition for TJ, was the plaintiff and the petitioner in the case. And the Fourth Circuit sustained their admissions program, and the essential issue in TJ was, is it okay to have a system of admissions that is race neutral on its face, but there was some evidence before the district court, which ruled in favor of the plaintiffs, suggesting that this race neutral scheme was adopted for race conscious reasons, e.g. there are too many Asians. And the Fourth Circuit had this kind of weird analysis where they said, well, they basically said, regardless, there were still plenty of Asians after the change, and they're still overrepresented in the TJ population relative to the relevant school district, so it's all good. And Justice Alito basically said, no, that can't be the analysis, but he did not get enough votes to have cert granted in that case.
And just to piggyback off of that, one of the things too is under the 1981 claims, disparate impact analysis doesn't exist under the 1981 claims. So it's that wouldn't be available, but under Title VII, absolutely, I think you could see that.
I've always been flummoxed by the outrage that the anti-affirmative backlash movement has had, because affirmative action has always been such an incredibly small number of students impacted. The legacy admissions are much, much larger. The athletic admissions are much, much larger. Affirmative action was supposed to be a program that lifted folks that had been historically discriminated against. You can't come to our school. For decades, it was supposed to lift folks into those schools, and yet Bakke made it so hard that it's been an incredibly small amount of people that have been admitted based on affirmative action. It's outsized, I think, in the outrage against it, because the legacy admissions that we're talking about here and the athletic admissions and others are just so much more significant, and I think not impacted by SFFA. I think legacy admissions, athletic admissions, I'm getting on a flight tonight to fly to Boston to take my niece to Harvard University as a member of the Harvard female rugby team that won the national championship last year, by the way. And she's Polynesian. My wife is Polynesian, and this is her sister's daughter. So that's the diversity they want at Harvard, but she runs over people on the rugby team, and she's in. I didn't ask her what her scores were. She's a very, very bright girl, but she's an athletic admit, right? And that's so much more significant in the whole admission scheme than affirmative action has ever been. And yet we have Supreme Court opinions and outrage.
I agree with Dean Cummings. I don't think SFFA affects legacy. But one thing that was interesting in the discovery in the trial court was they showed, and this is what I would do if I were king, and this is granted, this is a policy thing, not a legal thing. But the discovery in SFFA showed that if Harvard got rid of legacy admits, athletic admits, faculty kid admits, so-called dean's list, which is I have a lot of money to donate to Harvard, if they got rid of all of those and the racial preferences, the representation of Black and Latino students at Harvard would decline only slightly. But Harvard has to give up legacies and development prospects and athletes, and Harvard doesn't want to do that. Oh, and by the way, I think average SAT scores, clutch your pearls here, we're going to drop by like 20 points. And Harvard basically said that's horrible, and Judge Burroughs, the district judge, said, oh yes, that's horrible, you don't have to do that.
All right, time for maybe one more question, if anyone wants. No? All right, that's fine. I'm happy to let us turn over to the bar. Everybody, I want to thank our panel. This is really an excellent discussion. Thank you.
It was a great